technology, and last night Lord Goldsmith actually mentioned technology as one of the key things that would be necessary to make the center attractive. So Jennifer, can you give us an idea of what type of technology we can expect to be available at the center? It may be a little early, but
well, not that it's a little bit early. Basically, you heard from Cherno that we're looking to get the human resources in place. In addition to that, there's a beehive of activity really going on with regards to establishment of the center, one of which is the securing of the space for the physical center. We're at an advanced stage now in securing a lease for 9,000 square feet, which will be our initial space. And so simultaneously, we are also talking with interior designers and architects about the space and about the use for the space. So we have had some initial conversations about the technology to be in use at the center. We recognize that not being in a geographically central location adds to our requirements in that regard. But we've been fortunate that as we've convened the activities of the focus group, because of our Asia operations through BVI House Asia, we were in the region and were fortunate enough to meet with executives and others at centers, the centers both in Hong Kong and Singapore, which we've heard a lot about both today and last evening. And so we have a very good idea of what we need to do and what we need to have available to our clientele in order to compete with those jurisdictions in the way of both technology and general amenities and services that the center will offer.
Well, you're talking about being able to compete with other jurisdictions, but I think this is the question that everyone is waiting to be answered. So Brodrick, I'm going to throw this one back at you and say let's discuss labor and immigration issues. Because I know that is what everyone is, and I'm getting some faces in the audience, so I know persons are waiting to hear about that. I mean, it's a big issue, and it can be a thorny issue at times. When you look at the policies in place in relation to entry into the territory, visa requirements for work permits, does the government have any plans to ease these requirements in order to facilitate the development of this industry?
For fear of repeating what the other government employee that was on the panel said this morning, Mr. Jerry Ferrara QC, in short, the answer is yes.
I must have stepped out of the room, sorry.
But actually, I think Jerry did a good job this morning explaining his role as a sponsor of another one of our priority initiatives in terms of developing the financial services industry with a focus on immigration and labor. I don't think he tipped his hat in terms of what's actually coming, but I think it's safe to say that we are going to have some changes to the regime. I suspect that the changes could probably come in two forms. Firstly, a streamlining of the existing procedures to be able to facilitate business, not just arbitration, but business in general. And the streamlining could likely come in the form of exemptions, waivers, etc. Jerry hasn't made any recommendations. This is what I'm thinking about off of the top of my head and off of discussions that we've actually had internally. So I think streamlining on the one hand, but probably more fundamentally a reorganization of the process through a merging of the work permit issuing process and the immigration clearance process. Those of you that are familiar with what exists now, you get your work clearance from the Labor Department, you get your immigration clearance from the Immigration Department, and sometimes they're not necessarily in sync. One follows the other. I see no reason why they shouldn't happen simultaneously. Complicating that they're under two different ministerial portfolios. So I believe that it makes good sense and I certainly would support it, to have a merger effectively of those two processes by amalgamating them under the same ministry. So I think those two changes will fundamentally change the perception of the issues that exist now as it relates to both labor and immigration clearances in the BVI.
Okay. Well, I think we heard a lot, especially in the last panel, about the arbitration clauses, and I was wondering, Mr. Jallow, if you and perhaps Jennifer could weigh in on your and give me your thoughts on making the BVI the seat of arbitration for disputes involving BVI business companies through the inclusion of an arbitration clause in the M&As of BVI business companies.
I heard the last panel speak about it, and I think I thought they exhausted it, frankly speaking. But I'll still say a little bit about it. I will simply start by endorsing what has already been said in terms of practitioners trying to encourage their clients to accept the inclusion in their articles, like the Articles of Association, a simple model clause. And one of the things we've done in the rules that we have devised, there is a model clause. There are in fact two model clauses which are optional. Those to be developed and included in the articles. Obviously, you have to make sure that the model clause is fully cognizant of the fundamentals that need to go into it for it to be effective. Things like specifically mentioning the seat of arbitration, the number of arbitrators, which is optional, but that would be key. And even more important is the language of the arbitration, and the fact that the parties have agreed to, refer their disputes to arbitration. I think these are fundamental aspects that need to go into any arbitration model clause. So what we have tried to do, and again, this hasn't come to fruition yet. We are in the process of amending the BVI Business Companies Act, and a draft went out to the industry, and we've received quite a number of responses. And one of the suggestions in that draft is to give latitude, basically, to persons utilizing the model clause in their articles, so that disputes between the company and any other party, or between the company and members, or amongst members themselves, could be referred for resolution by way of arbitration. That simple provision is there in that, and it is designed specifically because we want to take advantage of the number of companies that are incorporated in the BVI, and we think this is where the practitioners can really aid the process. Because you are the ones in direct contact with clients, you are the ones who render advice, and it's for you to advise them of the option of utilizing that particular provision in their articles. And I think that certainly is going to be extremely helpful and will help in terms of steering this new regime forward into the annals that we expect it to be.
Yeah, I agree with Cherno. Numbers don't lie, and William, I believe, put up the numbers on the active business companies at about 450,000. And then the new companies, he correctly estimated at about 55,000 per year. So even if a fraction of those were to introduce the arbitration clause, it's a potential for business that we didn't have before. So I agree.
Well, thank you. I actually have a few more questions, but I think I'm going to stop now and give the audience a chance to ask any questions that they might have for the panel. Does anyone have any questions for our panel?
I would just counsel that the use of the arbitration center does not necessarily translate into it BVI being the seat. I think that distinction has to be made, so that the seat although it's an arbitration to be administered by the center, could be elsewhere, which begs the question then as to whether or not the center would be able to manage an arbitration that's in another seat, which goes to the question of credibility and it goes to the question of preparedness. That's the first comment. The second one is a good one with respect to the languages, because Latin America, for example, is a good market to be able to try to develop business there and have people use that. But obviously, if you don't have the language capacity at the center, then you have a question, again, which goes to credibility and usefulness. The third comment I would make is that the center should also be, and I see in the actual law that there is a catch-all provision at the end that says, and any other business that the board or whomever would deem necessary. And I hope that that would include the center actually performing a function of capacity building. Because if you look at a lot of the major centers around, one of the things they do very well is to actually put on courses, put on conferences, and they take that around the globe. So now if we can identify adequate markets where we can expect that they would favor using the center, then you want to be able to have a capacity to be able to promote conferences and a lot of the needed infrastructure and capacity building activities that would promote BVI again, because that's an important marketing tool. If you can go out and you can show, well, we're doing capacity building, the next question I as a user would say, this is someplace I would look closer to with respect to how they actually conduct the arbitration process. So I think there are a number of things that you can do to be able to do this.
Well, thank you for your comments, and you're absolutely right. And that is why we're working so hard to try and get it right. Because we know with the challenges that we have, with accessibility and infrastructure, we have to make sure that we go above and beyond to prove that we can actually compete as an attractive international arbitration center.
The word you use, compete, I don't know how to compete. You can work you can work with other places to be able to promote that. One of the interesting statistics that Brodrick talked about, that Queen Mary's that study. And one of the things, talked about 7% of Paris, 7% of
Singapore,
New York, and if you look, there's a number at the bottom. About 30% are people who are undecided. They have no affiliation with anybody. Now that's a huge number. One of the reasons that London is successful is because a lot of people are familiar and they feel comfortable with English law. But guess what?
we have English law.
Well, we are definitely going to make sure that we try to be as viable as possible. Are there any other questions?
If I could just react to something that the professor said. As he was speaking, I'm thinking he's reading from our playbook. I keep talking about these priority initiatives, right? Guess what? Capacity building is another one of our 10 priority initiatives. We're pursuing it through different means, but we recognize that the sustainability of any industry that we build in the BVI, we need to build capacity, and we actually need to build local capacity. We recognize that we're going to have to depend on the external capacity to help us build the local capacity, but it certainly is a measure that we are pursuing. Never thought about it in the context of the arbitration center, but within the wider context, yes, completely agree with you.
I think somebody referred to this week as arbitration week. For us, it is our embryonic approach, if you will, to capacity building in that area. And hopefully next year down in Russell, we will have a full week of activities with the center involved integrally, and you'll see the results of that initial initiative in capacity building in that area.
Just, on the question of accessibility, there was some discussion around streamlining the visa process. I wonder if another thing to consider might not be an exemption from the visa process for parties coming with respect to arbitrations, as has been done in Malaysia, for example.
Fully in agreement with you. I think I mentioned streamlining both in the context of waivers and exemptions, but it is quite possible. Interestingly, what is being presented to us as issues now as it relates to arbitration, there are issues in relation to other aspects of the business, particularly as it relates to litigation, for example, when a very experienced counsel need to come from outside, or a major party. Sometimes we end up with people from very, very foreign jurisdictions that need visas and so forth, and we have some mechanisms to be able to facilitate it. But I completely agree with you that exemption is probably one of the ways that we're going to pursue in relation to that.
Kelly, here's a question.
I just want to echo Alva's observation about separating the rules from the seat, and separating the document center from the advancement of BVI as a location for arbitration, because there will be parties who will wish to agree upon ad hoc resolution in the BVI regardless. And there's also sometimes some more training that goes on between the rules or the administration of arbitration and the location or the seat of the application. So you will have ICDR arbitration, for example, in Toronto, sometimes where that is the happy compromise between Canadian and American parties in the corporation. You may well want to provide that sort of leadership in a region, for example, where from another island or from the U.S., they wish to use BBI administration, incentives to administer the arbitration, they wish to have another location where their consumer seat is that. And perhaps they're in somewhere else. So you wish to give parties a variety of options, and that way keep the administration development and the BBI development separate.
And I think when you see the rules, when they are eventually made, that is there already in the draft. And I think that is recognized generally, and it certainly is helpful. It's one of the things that we envisage will need to happen, because it's in the nature of arbitration. The parties may want to use the administrator, but have the seat in a different location. And that's certainly in the model, in the model rule or the draft rules that have been prepared. But that's certainly helpful.
Can I just follow Professor Walker? You can separate seat and venue, you can separate administration, you can do all of that. The only thing I would recommend you keep in mind is you want the arbitration actually to be here. You don't want to find a situation, and it's very easy, to have BVIC arbitration taking place in
Miami
hotel or another sector. That's not going to bring the economic benefits, that's not going to bring the infrastructural benefits that we're looking for. So, yes, of course, but the prize is, whether or not the seat is here, to make sure that the arbitration is taking place.
Well, Lord Goldsmith, it's interesting you said that, because, as soon as the BVI Arbitration Act was passed, we got a request from a particular jurisdiction, which will remain unnamed, as to whether they could enter into arrangements whereby BVI arbitrations could be held in that jurisdiction. And we said, well, what's the benefit to us establishing ourselves? It didn't make sense to us. Yes, the objective is certainly to promote the BVI, to encourage clients to arbitrate in the BVI, because that's where the added value benefit really will arise to the will inure to the jurisdiction, and that's something we are seeking to promote, while at the same time not restricting the parties, in deciding where the venue is going to be or where the seat is going to be. That's entirely up to them. But I think And this is what we try to encourage all the practitioners to bear in mind. This has to be a collective effort in terms of promoting arbitration in the BVI. And there has to be a collective effort, and that's really where the benefit for the jurisdiction would lie.
All right, well, I've been given the signal, so I'm just going to thank the panel for that interesting discussion. And before they leave, I just want to give them a chance to each just quickly tell us why persons should choose the BBI.
I guess I go first. Well, I think we're excited about adding to the offerings from the jurisdiction. We're excited about the sector. Obviously, we believe there's a lot that we have to offer, and so we want to go out there and encourage people that we have, we're selling exemplary service in an enviable location.
Well, in one simple sentence, a flexible, modern arbitration legislation that prevents too much interference from the courts. And if I may add to that, I just want to raise one other matter that came up in the last panel, but I feel the urge to speak about it, which is the reference to the Legal Profession Act that William raised. Now, if you look at Section 61 of the Arbitration Act, it excludes the application of Part 4 of the Eastern Caribbean Supreme Court Act. Now, that part has been repealed, but then you have to use the Interpretation Act to realize that, in fact, it also excludes the Legal Profession Act, because that's the rule under the Interpretation Act, where reference is made to an act, and that act has been repealed or amended or whatever, the same reference will apply in relation to the new legislation. So I think we need to make that correlation. And Part 4 of Cap 80 was the one that dealt specifically with the admission and practice of law in the BVI. So that has been repealed now and replaced with the same provision you will have to read into that section. But nevertheless, we can continue to debate this. If it becomes absolutely necessary to put it beyond doubt, I'm sure the government will be amenable to clarifying the position by way of an amendment. But I just thought I needed to say that.
Brodrick, you have a final word?
This is why we love Cherno, because he knows how to clarify. I think my final word is really just to reiterate government's commitment to this entire process, government's commitment to arbitration. We've farmed it off in terms of its development, but we're putting our money behind of it. We are also going to be there to facilitate. We're going to work with the stakeholders, with the center, its board, the practitioners in the industry to be able to make this a success. I wear another hat in the tourism space. We like to see synergies between our industries. I know one of the panelists was speaking this morning about arbitrators coming to do their business and so on and so forth. But one of the things that I reflected on when he said that is that arbitrators, by their very nature, are rational people. I don't think it takes much rationalization to recognize that if you come to the BVI to arbitrate, you're probably in one of the most beautiful places in the world. And if you can't take the opportunity to leverage what we have to offer in tourism, then you're probably not going to be an arbitrator for me. So I just want to say, let's leverage the opportunities that we have together to be able to build BVI on all fronts.
Thank you.